Like more green. So we are here today. The Subcommittee on Immigration Citizenship is in order, and we're here today to explore an aspect of our immigration system that generally receives far less attention than ICE community raids, migration flow from Central America, mistreatment of families at the border. Although these are very serious issues that this subcommittee will continue to examine, the current situation at USCIS must not be overlooked. Record high case backlogs and policy changes that make it harder to obtain immigration benefits are extremely important matters that deserve careful attention. These are profound problems that have a direct impact on countless individuals, families, students, business, and other entities such as hospitals and research institutions. I'm sure that others on this subcommittee will agree when I say that we hear about these issues from constituents on an almost daily basis. Although USCIS has struggled with processing delays and backlogs since its creation, the agency reports that the current net backlog as of April 2019 stands at more than 2.4 million cases. This represents an incredible 344% increase from the net backlog of cases in 2014. It is the largest net backlog since 2003, when adjudications ground to a halt in the aftermath of the 9/11 terrorist attacks. Backlogs and processing delays create real-life problems for people trying to navigate our complex immigration system. Imagine a domestic violence survivor unable to escape her abuser because her request for protection has languished 4 months. A startup company abandoning a key project that will lead to substantial job creation because it is unable to get a visa for a specialty engineer. Families that remain separated for months longer than necessary because of delays associated with enhanced vetting. This hearing will provide an opportunity to dig deeper into these stories and examine how USCIS processing delays impact everyday people. We will also explore with our first panel of witnesses what is causing these delays and how USCIS plans to bring processing times back down to reasonable levels. Although USCIS has attributed the backlog to increased filings, staffing issues, resource shortages, and other operational factors, there's clearly another driver. New policy and procedural changes implemented by the current administration are substantially changing the way immigration benefit requests are adjudicated. Since President Trump's inauguration, the administration has eradicated a number of what I think are common sense policies that have for years helped streamline processing in favor of new policies that add bureaucratic red tape and divert resources by adding new burdens on adjudicators. Based on USCIS published data, it appears that these new policies have also increased the odds of receiving a denial. And when denials are appealed and overturned, that means more delay and more red tape, but without good reason. Processing delays and policy changes are making it more difficult than ever for qualified applicants to get immigration status. This difficulty keeps many individuals from being fully productive members of our society and our economy that they would otherwise be. Others may be reluctant to do things that ultimately benefit our country out of fear of interacting with the administration. I look forward to today's testimony so that we can better understand the purpose and intent of recent policy changes, as well as their impact on the development of immigration case backlogs. My hope is that with today's hearing, we not only hear about how these problems can be addressed with appropriate administrative solutions, but that we also determine whether legislative fixes are necessary. I would turn now to the ranking member, Mr. Buck, for his opening statement.
I thank the chair. I appreciate the chair holding this hearing to examine USCIS adjudication wait times and policy changes. This subcommittee has an important oversight responsibility, and adjudication wait times fall squarely within the kinds of issues we should watch. That said, I wish I had heard the same concerns and outrage from my colleagues when President Obama's DACA program resulted in long adjudication wait times for immediate relative green card applications, among other immigration benefits. Even the New York Times took notice of the increase in adjudication times. A February 8, 2014 article by Julia Preston stated, "Many thousands of Americans seeking green cards for foreign spouses or other immediate relatives have been separated from them for a year or more because of swelling bureaucratic delays at a federal immigration agency in recent months. The long waits came when the agency, Citizenship and Immigration Services, shifted attention and resources to a program President Obama started in 2012 to give deportation deferrals to young undocumented immigrants, according to administration officials and official data." End of quote. And I don't recall any concerns raised about what the backlogs would look like when my colleagues were marking up or passing H.R. 6, the bill that would have required USCIS to process millions and millions of green card and naturalization applications, whether or not the alien was ultimately granted such status. The volume of immigration benefits requests received by USCIS varies. According to the Department of Homeland Security, in any given year, USCIS administers a broad range of programs through which it receives millions of immigration benefit applications and petitions. In fiscal year 2018 alone, more than 8 million immigration benefits were requested, and that was actually a decrease from the 9 million requested during fiscal year 2017. Despite the huge volume of receipts in the last few years, USCIS still managed to naturalize nearly 757,000 new U.S. citizens during fiscal year 2018, more than in any of the previous 5 years. And fiscal year 2018 also saw USCIS adjudicate more immigration benefits than ever in its history. They should be commended for those accomplishments. To be clear, immigration benefits should be promptly adjudicated. Everyone here would agree with that. It is important that USCIS abide by its mission to efficiently and fairly adjudicate requests for immigration benefits. But it's also important for the agency to adhere to the rest of its mission, to administer the nation's lawful immigration system, safeguarding its integrity and promise while protecting Americans, securing the homeland, and honoring our values. Immigration benefits should not be delayed for nefarious purposes, nor should they be rubber-stamped, as we have seen happen during other administrations. As we have seen, many factors contribute to the volume of benefit requests and thus the time it takes to adjudicate them. So what kind of factors contribute to increased volume? Historically, presidential elections have led to increases in naturalization applications. Those who want to vote apply for naturalization right before the election. And administrative action can increase the volume too. As I noted, the DACA program to date has added 2.4 million adjudications to USCIS's workload. And of course, even Congress can add to the volume. When we create a new immigration benefit or push the increased numbers in a given category, that also adds to USCIS's workload. Unfortunately, USCIS seems to be inherently behind the curve given that its staffing ability is dictated by agency funding, and funding is dependent on less than flexible fee rules. There is no doubt that USCIS should remain a fee-funded agency. U.S. taxpayers should not bear the burden of paying for immigration benefits for foreign nationals. But I looked forward to hearing from the USCIS today any ideas the agency has for ensuring a fee rule and other procedures that allow flexibility to increase and decrease staff with the rise and fall of receipt volume. With regard to recent policy changes at USCIS about which the majority and some of their witnesses are raising concerns, again, ensuring the integrity of our immigration system is paramount, but that should be balanced with reasonable policies and procedures. Recently, USCIS instituted a sensible change in policy to end the practice of filing an application containing little, if any, evidence of eligibility, just to reserve a place in the adjudication line. This imposes an additional burden on USCIS and adds to the backlog. It is also important that adjudicators have the ability to issue notices to appear to protect national security and prevent fraud. I look forward to the witness's testimony to get a true understanding of the adjudication backlog and the factors contributing to it. I thank the chair and yield back.
Gentleman yields back. I recognize the chairman of the full committee, Mr. Madler, for his opening statement.
Thank the chair. Today's hearing examines a critically significant issue: policy changes and processing delays at U.S. Citizenship and Immigration Services, or USCIS. It is important to remember that the immigration debate in this country does not start and stop at the southern border. Although the Trump administration has focused most of its attention on curbing the rights of asylum seekers and threatening mass enforcement sweeps, the legal immigration system is not immune from dramatic policy changes as well. changes that have significantly diminished the ability of individuals to enter and to remain in the United States legally. Most of the policy changes that have been implemented by the administration appear to be intended to make adjudications more complicated and therefore more time-consuming and more difficult for individuals to obtain legal status in this country. From my perspective, these policy changes seem to fix things that were not broken to begin with and only serve to create unnecessary obstacles to legal immigration. For example, last August, USCIS suddenly announced that it would impose harsh penalties on non-immigrant students who violate their status, even if the violation was not knowing or intentional, was based on a technical error, or was de minimis. Thankfully, the court stepped in and this policy is now on hold. Another example is the USCIS's determination, without any justification, of its longstanding policy of waiving the in-person interview requirement for employment-based green card applicants. Most of these individuals have been in the United States for years on temporary visas and have been screened and vetted repeatedly. Waiving the interview, therefore, except in cases where fraud is suspected or there is some other issue, was a smart way to make the process more efficient. Now interviews are mandatory for everyone, and backlogs are growing exponentially. And let us not forget the public charge rule, which would dramatically heighten the standard for determining whether a person is likely to be reliant on public services and is therefore ineligible for a visa or green card. Basic services like Medicaid, SNAP, and Section 8 rental housing assistance that millions of working Americans use to supplement their income would suddenly render someone ineligible. Although the rule has not been finalized yet, it will likely be finalized soon. Setting aside the fact that it is clearly unlawful and morally repugnant, if finalized as proposed, there is no doubt that this rule will make immigration adjudications infinitely more complex. Over the past few, as predictions as to whether people with working permits will need at some point to avail themselves of Medicaid or SNAP or Section 8 rental housing assistance or other things now become necessary for these determinations on a predictive basis. Over the past few years, we have seen significant increases in processing delays and case backlogs at USCIS. The backlog of citizenship applications nearly doubled from 367,000 in late 2015 to about 740,000 in September 2018. In my district, most applicants for citizenship now must wait at least a year for their application to be processed, and sometimes even 2 years. USCIS has said that increased receipts, staffing issues, resource shortages, and other operational factors have led to the current net backlog of 2.4 million cases. As of the end of fiscal year 2018, it appears that processing times for most applications and petitions equaled or exceeded near record long averages. But it does not stop with processing delays. Denials of immigration benefit requests, such as citizenship, permanent residence, and work permits, are also on the rise. New policies, longer delays, and increasing denials have only added to the palpable fear, confusion, and uncertainty that permeates immigrant communities. I look forward to hearing from our USCIS witnesses about how the agency plans to bring processing times back down to reasonable levels, and from our non-government witnesses about how USCIS policy changes and case delays impact individuals and businesses alike. I thank the Chair, Ms. Lofgren, for her leadership on this issue and for holding this important hearing. I yield back the balance of my time.
Gentleman yields back, and the ranking member of the full committee will be invited to submit his statement for the record unless he is able to attend, which I think he has another obligation. So now we will introduce our first panel. There will be 2 panels of witnesses for today's hearing. The first panel includes 3 witnesses from U.S. Citizenship and Immigration Services. This panel will be followed by a panel of witnesses from non-governmental organizations. I'll now introduce the first panel of witnesses. Don Neufeld is the Associate Director of the Service Center Operations Directorate of USCIS, where he oversees the activities of the 5 remote processing centers throughout the country that adjudicate the bulk of immigration benefit requests. He's worked for more than 2 decades at USCIS and the former Immigration and Nationality Service, holding various leadership positions throughout the years. Mr. Neufeld has testified before this committee once before in 2011 for hearing on H-1B visas, and we welcome him back to the subcommittee today. Looking forward to his testimony. Michael Valverde is Deputy Associate Director of USCIS Field Operations Directorate, which oversees the operations of the National Benefits Center and the domestic field offices, which primarily handle applications that require in-person interviews, such as green card and naturalization applications. He has 2 decades of experience with USCIS and the former INS. He served as Performance Management and Planning Chief for the USCIS's Refugee Asylum and International Operations Directorate and Deputy Chief of USCIS's Refugee Affairs Division, and we thank him for taking the time to share his expertise with us today. And finally, Michael Hafer is the Chief of the Office of Performance Quality at USCIS. The office provides data and operational analysis to various governmental agencies and to Congress to oversee the efficiency of USCIS operations. Mr. Hafer previously served as Director of DHS's Office of Immigration Statistics, and it was in that capacity that he appeared before this subcommittee in 2007 to testify on the topic of comprehensive immigration reform. We welcome him back to the committee and look forward to his testimony. So at this point, I would ask you all to rise, raise your right hand, and we will swear you in. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Thank you. Let it be shown that all the witnesses applied in the affirmative. Please be seated. And we will note that each one of your written statements will be made a part of the official record. We ask that your testimony be about 5 minutes. When you've got 1 minute left, the yellow light will go on, and it's red when your 5 minutes are up. So we begin with you, Mr. Neufeld.
Chairwoman Lofgren, Ranking Member Buck, distinguished members of the subcommittee, thank you for this opportunity to discuss our agency, USCIS, better known as...
Could you pull the microphone a little bit closer?
Can you hear me?
Much better, thank you.
Okay, great. Thank you for this opportunity to discuss our agency, U.S. Citizenship and Immigration Services, and the challenges we face in administering the nation's legal immigration system. I am Don Neufeld, Associate Director of the Service Center Operations Directorate. I have served in this capacity since 2010. My career with USCIS and the Immigration and Naturalization Service before that dates back to 1983. Service Center Operations employs approximately 7,300 employees and contractors at 5 service centers across the country and at headquarters. To give you an idea of the volume of our work, in fiscal year 2018, Service Center Operations processed approximately 5.5 million applications and petitions. That figure represents 66% of the total USCIS adjudications output. Our work generally focuses on applications and petitions that do not require face-to-face interviews. These include employment-based and family-based petitions, applications for employment authorization, applications and petitions for certain humanitarian benefits, and applications for advanced parole and travel permits. Service Center Operations seeks to maximize process efficiencies and use technology to provide timely and high-quality services for applicants and petitioners, all without sacrificing the integrity or security of our nation's immigration system. We strive to maintain reasonable processing times and establish goals to measure our success. We are aware of the consequences for applicants and petitioners when we are unable to meet expectations. Indeed, your staff informs us when we are missing our processing time goals, and they share individual stories of how delays affect businesses and individuals. As we have detailed in our written testimony, there are a number of factors that drive backlogs. At Service Center Operations, spikes in receipts is one major factor. Other factors include statutory changes, unanticipated or irregular workload demands, workloads related to new immigration programs or humanitarian crises, application spikes related to fee increases, and staffing shortages. Some specific events that have contributed to the current backlog include the spike in receipts prior to the 2016 fee rule, the addition of temporary protected status for 5 countries, and growth in petitions for victims of certain qualifying criminal activity. We should note, we generally expect increased receipts prior to a fee roll and in advance of the presidential election. Following the 2016 fee increase and the 2016 presidential election, the anticipated decrease in receipts did not follow. While we do our best to anticipate short and long-term demands, we simply cannot predict everything that will affect our workload. Even when history tells us that something will happen, it doesn't always play out the way we think. Our current backlogs are largely the product of a sustained demand for immigration benefits coupled with staffing shortages. The good news is that we believe the demand has, for the time being at least, stabilized. As we continue to bring new staff on board, we will be able to better manage and reduce the backlog. In service center operations, we can adjust workloads between service centers when excess work exists in one service center and capacity and expertise exists at another service center. In the future, as we realize the efficiencies of e-processing, we will be able to do this in a paperless environment, saving time and money. We are also identifying administrative processes that can be moved from an adjudicator's desk to administrative or contract staff. In closing, we are committed to reducing processing times and offering superior quality services while administering our nation's legal immigration system efficiently, securely, and fairly. Thank you once again for your interest in our agency and mission. I look forward to any questions you might have.
Thank you very much. Mr. Valverde, we'd be pleased to hear from you.
Chairwoman Lofgren, Ranking Member Buck, distinguished members of the subcommittee, thank you for this opportunity to discuss the workload challenges we face at USCIS. My name is Michael Valverde, and I am the Deputy Associate Director for Field Operations at USCIS. I have served in this capacity since 2015. My career with USCIS and the Immigration and Naturalization Service before that dates back to 1997. I am proud to represent more than 7,000 field operation employees across the nation who each day come to one of our 88 field offices, 24 district offices, 4 regional offices, the National Benefits Center, and the Immigrant Investor Program Office with the singular purpose of administering the nation's legal immigration program fairly, efficiently, and with the utmost integrity. The field operations workload largely consists of the adjudication of non-asylum applications and petitions that require face-to-face interviews and other on-the-ground work, including site visits. Most significantly, adjustment of status and naturalization casework occurs at field offices. In fiscal year 2018, USCIS naturalized 757,000 new citizens, a 5-year high. At the same time, we completed more than 640 applications for adjustment of status, also a many years high. Unfortunately, backlogs are not new to USCIS. Internal and external factors have affected pending workloads across the life of the agency. Indeed, at the time it was established in 2002, as the chairwoman noted, USCIS inherited a backlog of cases. That backlog largely resulted from delays in background checks and security checks that were implemented following the attacks of September 11, 2001. Since that time, a number of factors have affected our processing times and our ability to meet workload challenges timely. Today, many factors have resulted in lengthy processing times. Significantly increased receipts over the past several years have outpaced our ability to process the work. Other factors, such as statutory changes, citizenship drives, and the implementation of new procedural requirements, such as security checks, new immigration programs, and policy changes have impacted our processes and processing times. USCIS does its best to apply lessons learned from historical workload fluctuations, and I believe we do well at it. Sometimes, however, all of these factors can stress our ability to complete our work as quickly as we would like it. Are we satisfied that applicants wait as long as they do for decisions on their requests? No, we are not. So what are we doing to shorten the time it takes for applicants to get their decisions? We are taking advantage of the resources we have. We are hiring to increase capacity. Field operations has had an onboard percentage in the high 90s for several years running. We are evaluating key processes and procedures to maximize process integrity and minimize waste. We are taking advantage of electronic age tools to increase accuracy and efficiency. As just one example of these approaches, we recently implemented a program we call Information Services Modernization. This program is designed to free up a significant amount of field operations staff time to handle their core adjudicative activities and interviews rather than providing information in person, which we believe, and we believe the data are showing, can be done more correctly and faster via other means. Detailed in our written testimony are other efficiency initiatives and process reforms. These include reintroducing performance metrics for our field offices, leveraging electronic processing and automation, developing innovative scheduling methods, and finding new approaches to staffing and workplace management. And we are seeing results from this work. In fiscal year 2018, the staff of field operations produced more case completions and at a greater efficiency per officer than in prior years. And we believe we're doing our work responsibly. In this fiscal year, we're doing a significant amount of more fraud work than other years by a significant percentage, all while keeping production of case completions up. Finally, in this fiscal year, due to our operational reforms and decreasing receipts, we have seen processing times for both citizenship and adjustment of status begin to lessen. While USCIS has too often struggled with lengthy processing times, I am confident that we have the imagination and the determination to address this latest backlog and to do so responsibly. As I expect my colleagues would agree, no solution will be immediate and comprehensive. I do think that we will continue to see improvements in processing times, backlog elimination, and backlog prevention. Thank you once more for your interest in this important matter, and I'll be happy to answer any questions you may have.
Thank you very much. We'll now go to the members of the subcommittee for their questions. Oh, I'm sorry, Mr. Hafer, I do want to hear from you. And that was an oversight. Please begin.
Chairman Lofgren, Ranking Member Buck, distinguished members of the subcommittee. Thank you for your invitation to address the subcommittee and the opportunity to discuss the workload challenges we face at USCIS. I am Michael Hafer, Chief of the Office of Performance and Quality in the Management Directorate at USCIS. I have served in this capacity since 2016. My career with USCIS and the Immigration and Naturalization Service before that began at the INS Statistics Office in 1982. I also served as a director of DHS's Office of Immigration Statistics from 2004 to 2013. Based on that experience, I will provide you an overview of the primary factors that we believe have driven our current backlog and processing delays. I currently serve in the Management Directorate, which is responsible for multiple support functions such as procurement, facility and financial management, IT systems, human resources, and my area of responsibility for performance measurement and analysis. Specifically, my office makes initial recommendations of required staffing levels based on future workload projections and efficiency rates. As you can see, while the men and women of the Management Directorate do not directly adjudicate applications, they do provide the infrastructure and the means by which our agency performs and measures its work. As we've heard today, backlogs are not new to USCIS. U.S. experienced its highest backlog in 2013 at 3.6 million applications and petitions, due in part to increased security vetting following 9/11. The backlog of pending applications as of May 2019 is 2.4 million. What does the backlog mean to applicants and petitioners? Let me give an example of the impact of the backlog. It is taking 10 months to process naturalizations, whereas our goal is 5 months. We know from experience that it is possible through operational efficiencies and additional resources to reduce our backlog. The 2003 backlog was reduced by a series of initiatives, including a one-time congressional appropriation and the authority to use premium processing funds to hire additional staff. We were able to reduce the backlog to 50,000 by FY 2010, but it has risen each year since then. Most of the recent growth in the backlog was in fiscal years 2016 and 17. The backlog grew from 634,000 in 15 to 1.1 million in 16, and it increased to 2.3 million as of September 2017. More than 70% of the increase in the backlog between 2010 and now occurred in those 2 years. The backlog has stabilized since 2017, growing by only 110,000 during the past 20 months. There are many factors that contribute to changes in the backlog, but I want to discuss the most significant factors we identified for 2016 and 17, the timeline when we saw the most growth. We projected that our receipts would increase in 2016 and then decrease in 2017 due to the combined impact of two factors, the national election in November 2016 and a fee increase 1 month later. Naturalization receipts previously had always increased before a national election and then decreased in the following year. When a notice of proposed fee increase is published, it usually motivates applicants and petitioners to apply before the increases are implemented, especially for cases that are more discretionary, such as naturalizations. Receipts in 2016 increased a little more than we had projected, but unlike past election year cycle experience, receipts continue to decrease in 2017. The elevated receipt levels over the 2-year period were largely responsible for the growth in the backlog in 16 and 17. Receipt levels have returned to normal in 2018 and 19, which has helped us to reduce the growth in the backlog. Our total number of completions in 2018 were the highest ever, and we reached a 5-year high in the number of persons taking the oath of citizenship. The growth in the receipts has allowed us to continue to hire more staff and to increase overtime. Authorized FTEs increased 7% in 17 and 5% in 18. Increasing staff is an effective component to backlog reduction. It's effective but not immediate. Hiring and training new staff almost always takes a few years. Not a few years, we try to do it as quick as we can, but it's a reactive process. We have to identify funds, we have to recruit, we have to hire and train staff, and that can take months. Recognizing this, USCIS recently began modeling for a 6-year time horizon. Under this model, USCIS is able to proactively identify required staff so positions are filled by the time they're needed to achieve case completion targets. Such a process will not only allow USCIS to reduce the current backlog, but hopefully prevent a new one. I very much appreciate the time and attention you have given to my colleagues and me. Thank you once more, and we're here to answer your questions.
Thank you very, very much, and thanks to each one of you for that useful and informative testimony. We'll now go to members of the subcommittee who have questions under the 5-minute rule. I'd recognize first the ranking member for his questions.
I thank the chair. I'm going to yield to Mr. McClintock, and then if it's all right with the chair,
That would
I
be
will-
fine. We'll recognize Mr. McClintock then, and you later. Mr. McClintock.
Well, thank you, Madam Chairman. Mr. Hafer, didn't the information required of applicants double back in 2016? Didn't the form go from 10 pages to 20? Or for that matter, any of the panelists who...
If you're referring to the application for citizenship, yes, sir. I think it was back in 2012 or 13, the application
Okay, now I
doubled in
assume that
length.
means twice the information that you have to verify and consider for each application.
Yes, sir. That adds complexity and some length to our interviews.
Now, in addition to that, are you seeing an uptick in applications being filed for citizenship? I think I heard testimony to that effect, but I didn't hear how big an uptick.
Yes, we received a little bit under 1 million applications for naturalization in 2016 and a little under 1 million in 2017.
Okay, and how did that compare to, say, 10 years ago?
Well, we normally, I think we would average between 700 and 800,000 applications
So
a
it's
year.
gone from roughly 700 to 800,000 up to 1 million.
That's correct.
So roughly a 20-25% increase in the number of people who are applying.
That's correct, sir.
Okay, now, on the other side, how many applications are you actually processing, or approving, I should say?
I can do that. In the past fiscal year 18, we completed 750,000 approvals, and it was closer to 850,000 completions for naturalization for citizenship.
750,000 approvals, 850,000 completions, and what were those figures, say, 10 years ago?
I don't have them to heart, but they were lower than that. I can say that
Lower,
much.
much lower, significantly lower?
I don't have the numbers.
We did have some years where we're higher when, after there was increases in naturalizations in prior years as well, going back to the 90s, and I think in
Would you
one.
say that the number of applications being approved higher or lower than in the past?
I would say over the last 5 years, it is averaged higher, but there are particular years in the past where we had more than.
Okay, so the point I'm trying to get at is the amount of applications have increased dramatically, 20 to 25%. The amount of information you have to sort through has doubled with the doubling of the forms. And we're seeing a substantial increase in applications approved and naturalizations completed. So is the backlog then a function of those two issues, principally more information to go through and more applications to process?
Yes, I agree with that, and so it's partly the receipts that are coming in and how long it takes us to, the resources available to us to work those cases.
Great, thank you. Yield to the ranking member.
Gentleman yields back. We will now turn to the gentleman from California, Mr. Correa.
Thank you, Madam Chair, and I want to thank our witnesses for good work you're doing at USCIS. Let me follow up on some of the comments made by my colleague from California. High, low, after 9/11, 2013, the length of the application doubled, you said. Is that correct? 10 to 20 pages, and can understand why, security issues and what have you. So you doubled the amount of work you had to do for a citizenship application. Yet I would imagine that the automation since 2013 has increased. Is that correct? The processing,
Yes, sir. We're
personnel that you have. So productivity-wise, in terms of each individual, is that going up or down? Thorough processing per individual?
Productivity per officer has gone up this year from last. Yes, sir.
So it has gone up. You have about 700 plus minus new slots that you've been authorized, correct?
Agency-wide, yes, sir.
To hire. How are you doing in terms of hiring those individuals?
We've made hiring a focus of ours, and we've, in field operations, we've been in the high 90% of on-board staff
So
compared to
you're
what we're
moving
offering.
ahead at a pretty good pace to hire
Are
new people?
Doing all we can, yes, sir.
Thank you very much. And I say that to you before long time ago, before I got in government, I used to apply, fill out applications for citizenships. One of them was for my uncle, and I remember, God rest his soul, 70 years old, applied to be a U.S. citizen, lived here for 50 years. As an attorney, I filled out his application, waited for a year, called your office. They said, we lost the application. Filled it out again, waited another year. Application was lost. Third time, I didn't call. I went to Los Angeles to see what was going on. And a nice lady behind the counter said, let me go find your application. 2 hours later, she came back. You had a special line for attorneys. She came back with half the application. She said, we lost the other half of the application. She was very nice and said, look, I'm not going to make you wait another year. Pull over to the site. Here's the whole application packet. Go fill it out. And 3.5 years later, we finally made him a U.S. citizen. But I'm sure now we have a process system where paperwork is at a minimum. Am I correct in assuming that?
We have an electronic way to file, sir, but we still have a paper-based
Wonderful.
filing as well.
And I guess today, I'm trying to figure out, you're doing a great job given what you've got in front of you, but we have a lot of folks that have fulfilled their requirements to be Americans, the American dream, full U.S. citizens. And as I read through all this information, listening to your testimony, I'm trying to figure out what can we do, what can I do to help those individuals that want to be Americans fulfill that American dream of being an American. We gave you resources. I think we've authorized new personnel for you. You're in the process of hiring them. Do you need more resources for automation to make sure you cross-check all this information to make sure only the good people that deserve to be Americans become Americans? What else can we do to help you get your job done in a timely manner?
I think, well, I spoke about the training, when we hire and the training. I think one of the things that's where could be help is that we do have, we would like to expand our training facility at FLETC, and we have money designated for that, but we need authority from Congress to be able to expand that. So that would really help us to get people on board and trained and ready to work.
Anything else? I know, for example, hiring Border Patrol agents has been a challenge for us because of the lie detector test and the challenge there, but you don't have anything similar to that in terms of challenges hiring folks to, any other problems, anything else that we can do to help you expedite the process? Reduce the backlog.
I will say we are a fee-funded agency. For the most part, we get some appropriated funds, and so our ability to hire staff is dependent on the fees that we collect. And first, we need to collect those fees before we can spend them. And the other thing is those fees need to be set properly so that they cover our costs. And so I guess what I would ask is that when we periodically review our fee structure, that you be supportive of the fees that we need to set to recover our costs.
Gentleman's time has expired.
Thank you, Madam Chair.
The gentlelady from Arizona is recognized for 5 minutes.
Thank you, Madam Chair. Mr. Valverde, has anyone in this administration told you to slow down processing citizenship cases?
No, ma'am.
Has anyone in this administration told you to slow down any case processing?
No.
And Mr. Valverde, what do you say to those who claim you are trying to slow processing on purpose to prevent citizenship applicants from getting naturalized and becoming voters?
I would say that the data and the evidence shows the opposite. I'm lucky each day to be surrounded by colleagues who come to work to process immigration requests as efficiently and with the utmost integrity as we can, and they've spent their careers bringing people to the franchise. Whether they register to vote or not is another thing, but they've spent their careers helping people become citizens, and it's some of the proudest work we do.
Thank you, Mr. Valverde. And isn't it true that during fiscal year 18, your agency naturalized more people than in any of the previous 5 years?
Yes, ma'am.
Okay. Mr. Newfield, in the testimony in the next panel, Mr. Cohen will testify, I believe, that USCIS's new RFE NOID policy means that any small mistake or lack of information on an application could result in a denial without giving the applicant a chance to correct the mistake. Is this an accurate description of the policy?
So a request for evidence is that's something that we issue when the evidence that was submitted is insufficient to demonstrate that they're eligible for the benefit that they're seeking. And we issue requests for evidence for the purpose of allowing the applicant or petitioner to basically perfect their filing. The change that happened, there had been a previous to the change, there had been a policy that that said for the most part that where the evidence does not support an approval, that, but for a couple of circumstances, that the officer should, in all circumstances, issue a request for evidence or a notice of intent to deny. This change that you're referring to, or that the witness is referring to, was there was a change in the policy to clarify that where the record appears to be complete, that a decision can be rendered on the record without having to issue a request for evidence or issue a notice of intent to deny in all circumstances.
Thank you. And Mr. Hafer, is it? Hafer. The House recently passed H.R. 6, the American Dream and Promise Act, which would provide green cards and a path to citizenship to millions of illegal immigrants. I'm not going to ask you your thought on the bill, because you probably can't say that anyway, But I would like to ask you what the implication is going to be on operational aspects from that bill if it passed and became law.
Certainly. Well, I think a lot of it depends on how it's implemented and what the rules are for this. I mean, if there were 2 million people and 2 million applications, obviously that would have an immediate effect. And we've talked before about the lag. So if 2 million people showed up in a given year, and we haven't had the hiring and the money up front, say, certainly it would have an impact on the backlogs.
And thank you, Madam Chair. I don't have any more questions. Mr. Ranking Member, did you want any of my time? Okay, I yield back my time.
This microphone. Hello? There it goes. Thank you, Madam Chair, and thank you to the panel members for being here today. Obviously, we're here because of the unconscionable backlogs that many of us are experiencing throughout the country. Yet this administration is adding to the problem by imposing new hurdles for applicants in every step of the process. The Greater Houston area, one of the fastest growing and most diverse regions, which I represent, certainly appreciates the contributions that diversity brings to the local economy and culture. However, Houston's diverse economy and culture is greatly affected by these processing delays. In March 28th, Congressman Olson, also from Houston, and I led a letter from the Houston delegation to the former director, Mr. Cisna, outlining the harmful impact of these delays in the Houston community. Democrats and Republicans alike are concerned about the future of our families and businesses as the backlog problem continues. I might add that this letter was signed by all members of the Houston area delegation. According to the most recent USCIS data, the average time for an I-485 or green card application in Houston is currently at between 15 and 28 months. For an N-400 application for naturalization, the backlog varies between 14 to 21 months. For the I-765, the employment authorization, the delay can be up to 5 months, causing loss of wages for many applicants. The uncertainty experienced among applicants and those who depend on their contributions is disconcerting and unacceptable. Though we understand that staffing is up in the agency, it is a long process, requiring months of vetting for candidates, and we think that, of course, you all can do better. We have identified the problem, and now we must invest in solutions. Regrettably, Madam Chair, one of the questions we asked Mr. Cessna was, do you need additional statutory direction or funding to better respond in a timely way? He actually answered no, although USCIS appreciates the offer for assistance. I want to begin my questions with just that question to the 3 panel members today. Do you need additional statutory direction or funding? All 3 of you, just yes or no.
As my colleague said before, we're a fee-funded agency, so we'd appreciate the support when we next go to adjust our fees so that we get the right kind of funding for the casework that we need to do.
So your answering is yes.
I'm answering, we would appreciate the support as we look to adjust our fees.
Well, I'm glad you're saying yes, because I couldn't understand why the director, of course, who's no longer here, is saying no. Because it seems to me that we can do all that we can in providing support, but we need solutions coming from your agency. Now, all 3 of you are career, right? You're not political appointees?
Correct.
Right. So you all know how this works. Many of you have been here through many years. Like Mr. Huffner, you identified and said that the increases tend to come in terms of patterns right before an election or before a fee increase. Is that correct? Did I hear you correctly?
That's correct, ma'am.
All right, we have an election coming. Have you all already put in place some planning and processes to prepare for that, knowing that there will be an increase?
Yes, ma'am. Within field operations, we recognized the trend just that you referred to, that leading up to the election years, there's often an increase in applications. We also recognize the fact that the growth in receipts has not impacted equally across the country. So some of the work that we're doing right now is to try and ensure that the impacts of receipts, the impacts of pre-election application growth are addressed where they're most critical. That is to say, where there are places like Houston and others where the processing times are higher than we'd like and higher than some other places, we're doing the work there to make sure that an applicant's experience in Houston is more similar to an average applicant's experience across the nation.
Well, what really concerns me too, some of the things that we're hearing about some of the changes, number one, the fee increases, number two, is the idea that people may not get their interviews in the same location where they made their application, but may have to travel a great distance, and a couple of other things that just seem to be barriers rather than a path to getting the application done. So what is it that you are proposing that would actually help people get their applications timely processed and completed?
Gentlelady's time has expired, but the witnesses will please answer.
Thank you. It's a number of things. First, with respect to the changing of appointment jurisdiction, we have looked at the map and where there are locations where there are two field offices that are close and we can move a zip code or something like that. And that enables a group of applicants to have their case seen sooner. That's why we've done that. So those individuals, should they be able to travel, would get their case seen sooner, and it's for the purpose of getting the benefit faster. We're doing a number of things, as I've said in my testimony, so I won't repeat it here, around process reform, hiring, and other things to help everyone's case go faster.
Thank you. Thank you, Madam Chair. I yield back.
The gentleman from North Dakota is recognized for 5 minutes.
Thank you, Madam Chair. And before we get into that, I just want to clarify, so do we need additional congressional funding on top of fee funding?
I'll take that one. I think what we're saying is that and that one thing we should clarify, none of us manage or oversee the budget for USCIS, but as an executive, I'm aware of some of the constraints. And at present, we are unable to hire to the staffing levels that our workload would support because of our fiscal and budget constraints. And so I think it's safe to say that additional money would help. The source of that money, whether it's appropriated or fee funds, as an operator, it doesn't matter. It would just be helpful to have the staff.
And then I also appreciate the talk about significant distance. I married an immigrant, and we lived in rural North Dakota, and this is 2004. The process in and of itself is daunting, and this is coming from two pretty educated people. I had just graduated law school. She was in law school, but the bureaucracy is mind-numbing when you drive 350 miles to Minneapolis and show up for a hearing that was scheduled by immigration and get there and they tell you to go home because they're not ready for you. So you have to turn around and come back. It's not like going around the block. And I've practiced in this area, our firm has practiced in this area through 3 presidents now, 2 Republicans, 1 Democrat. And so I appreciate the fact that we're talking about the history of this, because this didn't all start on the first week in January of 2017. As throughout the campaign, throughout our office, I've met with people who are waiting on 2008 visa permits to be processed. And these are, researchers who work at the Langdon Research Center in North Dakota. Not exactly, there's 5 employees total, and the frustration level for not only them, but also for their employers and the community at large, when you have a community of under 1,200 people, and they become part of it. So I'm glad we're having this conversation, but I do have one pretty specific question relating to EB-5 background, or EB-5, the rules, and that's just, foreign nationals can apply for permanent residence if they make necessary investment in a company in targeted employment areas. And I know there's a rule in place which, as proposed, the EB-5 modernization regulation would increase the minimum investment amount significantly, transfer targeted employment areas designation from the state economic development agencies to the Department of Homeland Security, and create priority date retention for EB-5 investors to use the priority date as previously approved, and establish more federal oversight in regional centers, et cetera. USCIS submitted the proposed EB-5 Immigration Investor Program Modernization in February of 2019, correct?
Yes, sir.
And OMB finished its review of EB5 in June.
I understand they just recently finished its review, yes, sir.
Do you have a status update on where that is at?
It is still in the process, so it has not been published yet, as you know. I would expect that it will be published relatively soon, but I don't have a date to give you, sir.
Relatively soon, that's a pretty ambiguous, we like to use that term, but we don't, I mean, so months?
I would think it's less than months, sir.
Okay, thank you. I don't have any other questions. Yes?
I want to clarify one point with Mr. Neufeld and Mr. Valverde. You answered the question earlier, Mr. Valverde, about whether you believe it would be beneficial for Congress to appropriate money. And you didn't use a yes or a no, and then words were put in your mouth, and the answer was, well, I believe that's a yes. I didn't hear a yes, and I want to make sure there are benefits, are there not, to having a fee-funded system as opposed to an appropriation system for your agencies?
I'm not an expert in that area. I know enough to know that there are some profound differences, and I guess that's as much as I can say without getting myself.
So you just don't like yes or no answers, do you?
Would the gentleman yield?
Yes.
I would just note that really these are career, and they don't have really the luxury of opining. That's a policy decision for the Congress to make, but I don't think anyone is proposing that we move USCIS away from a fee-funded agency, just to clarify. And
I appreciate the chairwoman clarifying, because I think it's important. There is a perception that your agencies are fee-funded because the individuals that are applying pay those fees and not U.S. taxpayers. And I think that is an important perception for many in this country. And I appreciate the fact that you are operating under a fee schedule. And I yield bounce on my time. Okay, I yield back.
yield back, and the gentleman's time has expired. The gentleman from Colorado is recognized for 5 minutes.
Thank you, Madam Chair, for holding this important hearing. I just want to follow up on a point that was made by some of my colleagues a moment ago, because this isn't just about money. I mean, my sense of it, I just want a baseline set of facts. From fiscal year 2018 to fiscal year 2017, there was a 13% decrease, my understanding, in the volume of applications submitted. Does that sound about right?
I think it sounds about right, yes.
And from fiscal year 2018 to fiscal year 2017, your budget had a 6% increase. Does that sound about right?
Yeah.
So, in FTEs, precisely. So, I'm not making the case that there may be a resource allocation issue, but to the point that my colleague from Arizona made earlier when she posed the question to you as to whether or not you had been directed by anyone to slow walk applications and so forth, the central question, which I think you've answered in your written testimony, is have the promulgation of various policies that your agency has adopted in the last 2 years since the Trump administration took office, and perhaps at their behest, has that exacerbated the backlog? We understand that there was a backlog before January 1st of 2017, but I think your written testimony confirms that, yes, that is one of the reasons that there is a backlog. Accurate to say?
Well, let me go back to the question about the decrease in the receipts. I think as I testified, what happened is there is some lag when we get the receipts.
Yeah, I understand that, Mr. Hafer. I'm asking, I get, it's a simple question. Again, if you want, I guess we'll let your written testimony speak for itself. There are a variety of policies, in addition to a number of other factors, that have lengthened processing times. That's not a fair statement to make?
No, that is fair.
Okay,
that is fair.
so that's just baseline set of facts that I think we ought to operate under for purposes of this hearing. You know, I would say this. I appreciate the work that you all do, and I appreciate your service, and I appreciate you appearing here before us today. We have a serious problem. I mean, this backlog, which I understand has existed for quite some time, but has been exacerbated over the course of the last 2 fiscal years in particular, is not sustainable. A 344% increase from the net backlog of cases in 2014, when you look at a 5-year window. And in Colorado, in my state, and I know the ranking member, I suspect appreciates this as well. There is a long queue that is building and building, and so I appreciate your efforts. But I think we ought to, the point that my colleague from Texas made, we ought to be focusing on solutions to these problems. And one of the issues that I want to ask you all about, the backlog reduction plan that you've submitted, or the summary that you submitted, to this committee lists as one of your goals, or I should say, one of your initiatives that you intend to implement to address the backlog. It's number 5 in your list, redefining processing time goals to better reflect true cycle times, which I understand, based on your written testimony, was a recommendation made by the DHS Office of Inspector General. The way I read this is what you're saying is that right now, because the agency is unable to fulfill the 120-day goal for a variety of different applications, permanent resident applications and so forth, you intend to simply change the goal and extend, instead of saying it's going to be 120 days, make it 180 days. And I could just tell you, from my perspective, having run a regulatory agency back in Colorado with a much smaller, $90 million budget, 600 employees, appearing before our legislative committees of jurisdiction would not be received well if I said, well, I'm going to simply change the processing time because we can't meet it. Anyone have a way to explain that?
I'll respond to that briefly. The OIG statement to me said that the 120-day goal of all the things that the agency must do to process an application for adjustment of status, they're not feasible in 120 days, of all the background checks, fingerprint appointment, interview, etc. And thus we should go back and give the public a better expectation. From my perspective as an operator, one of the things over the years that has taken time away from our core adjudicative functions is responding to people who, reasonably say, when is my case going to be due?
Well, to that point, I would say I certainly agree that perhaps better responsiveness and increased communication throughout the process. I appreciate what you're doing with respect to the online programs that you've mentioned launching in your backlog reduction plan, and so that would, I think, accomplish what you're after. But extending the timeline so that it is, quote, unquote, more realistic, to me, is not an appropriate response to what is a critical backlog. Last piece I will just say is, you mentioned, Mr. Valverde, in respect to fees, right? Who pays your fees? Who pays the fees?
Our salaries come from the user fees.
User fees, and what do you call them?
Applicants and petitioners.
Well, for the existence, or since your agency was founded, we called them customers. That term was removed from your mission statement, as was the term nation of immigrants, a year ago. And in my view, some of this is cultural. To the extent we don't see individuals as customers, that this agency is set to serve as a result of the law that was passed by Congress back in 2002, I think it implicates the way in which we look at these delays and the plans that we make to comport with them. So with that, I would yield back.
Gentleman's time has expired. We turn now to the gentleman from Florida.
Thank you, Madam Chair. My first set of questions are for Mr. Valverde. In his testimony for the next panel that's after y'all's, Mr. Cohen highlights the denaturalization work that USCIS is undertaking. Isn't it true that this work focuses on individuals who fraudulently obtain citizenship and that the work began under the Obama administration? Can you explain what you were doing as it relates to that?
Absolutely. The work began in the late 2008 or 9 timeframe, and then was highlighted in an OIG report in 2016 when USCIS really got involved. But the short summary of the work is that in the course of uploading old paper files into our electronic fingerprint database, we started getting matches with different sets of biographic information. So what we were seeing in maybe simpler terms is 2 different identities connected to the same fingerprints. And what we saw is many of them had, unbeknownst to us, gone through the naturalization program and procured citizenship. So the work we started in 2016 and we continue today is to get those cases together. If it's 1 file, if it's 2 files or 3 files in some instances, compare the records and find the individuals who obtained the benefit, we think, through fraud, and write that up. There are some that we don't think that was the case, but for the ones that we do, we write that up into an affidavit and work with partners at Justice to for them to do the denaturalization process in the courts.
Okay. And also in his testimony, Mr. Cohen points out that the USCIS adjudicators are, quote, asking for more proof of marriage if the applicant is applying based on their marriage. If an applicant is applying based on their marriage, doesn't it only make sense that your adjudicators would ask questions about the marriage? I assume the purpose of these questions is to find out if there is fraud. And is marriage fraud a real issue that you see in the department?
Yeah, I won't comment on specific cases, but marriage fraud is an issue that we come across on a daily basis in many of our offices, and it is something that we give our officers special training for, so that they can pay attention to ensuring that it's a bona fide relationship that forms the basis of either the request for permanent residence or citizenship.
Well, I've even seen in my own district a case that was brought to my attention where the parties were allegedly married, and both the alleged wife was living with another man and the alleged husband was living with another woman. So it's definitely an issue. At least I've seen it in my district in the short time that I've been elected to Congress in the last 6 months. So I certainly think there is fraud as it relates to getting married and trying to get citizenship and access into our country. In her testimony for the next panel, Ms. Lint refers to interviews for individuals seeking green cards through their employers as unnecessary. Getting a green card comes with significant legal benefits and rights. Is that correct?
Yes, sir.
And would you agree that ensuring an alien is in fact eligible for a green card is important and required by law?
Yes.
And are the interviews for employment-based green cards adding unreasonable delays to the adjudication?
In my opinion, no, sir. I think it is a measure of integrity to have a face-to-face conversation and ascertain evidence about their eligibility for the benefit for someone who wants to remain here permanently, to live and travel and work here.
I have questions for Mr. Neufeld. How much time do I have left? Because I don't see a... Okay, Mr. Neufeld, isn't it true that if an adjudicator is adjudicating an application or petition and needs additional information in order to make a decision, the adjudicator has only two options, either issue a request for evidence or deny the application altogether? Is that correct?
Essentially, they can also issue a notice of intent to deny that would afford them an opportunity to respond before they would make the actual decision.
So they could have an opportunity to respond, but that's it. Either.
Yes.
Okay. And the latest USCIS Ombudsman report to Congress recommends that USCIS emphasize that petitioners and applicants verify the addresses provided for all forms filed with the USCIS. How much of a problem is it that people do not provide their current address?
I think it's more of a problem that their address might change, and so our records don't reflect the correct address. In the employment context, occasionally we will find where the attorney's address or the employer's address will be used as if it's the beneficiary's address, and then that can create some problems with us trying to sort through that when we adjudicate the case.
So if it's that type of scenario and they're not updating you of their new address, that obviously is delaying the delivery of their work permits and other documents from your agency.
Yes.
How am I doing?
Your time has expired.
Okay, all right, there you go. Thank you, Madam Chair.
The gentleman yields back. The gentlelady from Florida is recognized for 5 minutes.
Hello. I think that an efficient and service-oriented immigration system is vital to businesses, for our economy, mostly also for families that are living here in the United States. It allows families to be reunited with loved ones, and it enhances the diversity which makes this nation great. I am actually a naturalized citizen. I remember going through the process, and I'm so grateful that I was allowed that opportunity, but it did take years before we were eligible and allowed to become U.S. citizens. In recent years, we've seen that the backlog of cases at the USCIS has exploded. From 2016 to 2018, the net backlog of cases rose by nearly 1.4 million cases. In 2018, USCIS received 1 million fewer cases than the year before, but the average case processing delay continues to rise. The staggering backlog of cases at USCIS has created challenges for businesses, universities, hospitals, and mostly families, like I mentioned. Despite this, earlier this year, the administration announced that USCIS planned to close all international field offices. These offices are critical resources in processing refugee applications, family-based visa applications, and other immigration matters. My district in Miami serves a large population of Cuban Americans. And from one day to the next, the USCIS field office in Havana was closed. And as a result, families are now separated. I hear on a daily basis hundreds of some of my community members that are writing to us, calling to us. They tweet asking for a resolve for this issue. They tell me that they wouldn't have left Cuba if they knew that their sons and daughters would not be able to unite them here in Miami. So I wanted to first ask Mr. Valverde, who made the decision to close the office in Havana to process the parole and family-related visas for the Cubans that are applying for these visas?
I don't have the first answer to that. I understand it was the former director, though, but I wasn't.
Okay, so now that the Havana office is closed, what is the process for processing these applications and getting these families back together?
I think none of us on the panel are working in our overseas offices administration, so we'd have to get back to you. I do understand that the Havana office was closed after the attacks on our employees.
Yes, but there was never any evidence that it had to do with the government there, and now thousands of families actually are suffering the consequences of that closure without any responses. So if you could please provide me with that information within the next 2 weeks as to what the plan is to process those applications that were already started. And just as a general matter, how does closing a USCIS office impact the backlog the agency is seeing? Mr. Neufeld?
As my colleague mentioned, none of us here oversee the overseas offices, so we're a little bit challenged with this. As a service center executive, I would anticipate that some of that work that is presently performed overseas may be coming to the service centers, and we would need to prepare for that. So, for instance, I'm aware that on occasion, family-based petitions might be adjudicated on site at a international office, and I would anticipate that that work would be coming to a service center instead.
And so who made the decision in the agency to close all these field offices, international field offices?
Again, that's a bit of a challenge for us. As I understand it, the decision it hasn't been finalized in terms of specifically which offices are going to be closed.
And you are aware that a lot of these international field offices process international adoptions, they support refugee resettlement, and they handle family reunification applications. And in addition, in response to Mr. Subi's concern on fraud, they actually also deal with some of these fraudulent cases. So I'm concerned that there's not enough preparation in here nationally how we're going to prepare to closing these international field offices. Has USCIS or DHS conducted a cost-benefit analysis or otherwise studied the potential impact of these closures on the processing of refugees, adoptions, and other services? Is there a study that has been conducted?
I don't know.
Okay,
The
thank you.
gentlelady's time has expired,
Thank you very much.
and the gentlelady from Texas is recognized for 5 minutes.
Thank you, Madam Chair, and many thanks to those of you on the panel for being here, and thanks for your service. We have seen a theme this week with the hearings that we've had. We had a hearing yesterday on the horrific overcrowding in the El Paso processing facilities as documented by the Office of the Inspector General. And today, as laid out by my colleague, the gentleman from Colorado, we have seen also a terrible backlog that has been exacerbated by policy. And during yesterday's hearing, what finally surfaced was that policy by this administration was making a challenging situation worse. I believe that the same applies here. And just as an example of what we continue to have to face, in October of 2018, USCIS published a notice of proposed rulemaking that would dramatically heighten the standard for determining whether an individual is likely to become a public charge. In the background information on the proposed rule, DHS admitted that the new rule could lead to worse health outcomes, increased prevalence of communicable diseases, increased rates of poverty and housing instability, and reduced productivity and educational attainment. Setting aside the fact that the rule as proposed is illegal and exceeds the agency's statutory authority, I'd like to ask either Mr. Neufeld or Mr. Valverde the following questions. When can we expect final action from the agency on this rule?
I don't have a date on that. It's still going through the rulemaking process.
Okay. If finalized as proposed, will this new rule increase the amount of time it takes to adjudicate applications for adjustment of status and other benefits? And if so, what is the estimated additional time burden?
I'll take that as well. The rule change, like any change, will add a complexity as we train people and try to roll it out. I don't have an estimate right now because the rule has not been finalized and we don't have the final language that we'll have to apply to our cases.
Will you be evaluating how much extra time it will take, what kind of a burden it will add to the agency?
Absolutely. We evaluate either in the every 2-year fee process, how long it takes us to do all our actions, or in our annual budget process, that is how we allocate the staff that we have to do the work.
I would request that in your subsequent budget, once the rule has been applied, that you please make a note of that, of the additional time and the additional staffing that would be required in order to deal with the rule, please. Also, what steps has USCIS taken to prepare for the additional burdens that will be imposed on the adjudicatory process as a result of this rule? And what is the plan to ensure that processing delays on affected applications stay within reasonable timeframes? And that doesn't mean, as Mr. Nagus pointed out, that doesn't mean changing the goalposts. That means providing customer service in the appropriate time.
As I mentioned a minute ago, as soon as we get the final rule and we can build some processes and procedures around it, we'll have a better sense to answer your questions with some more specificities. But certainly as we are aware of the rule and as we've seen the proposed rule, we can make some guesses, and so we are doing our planning. We're taking that into account in our budget process this year. At this point, though, we're making some assumptions about application rates and other impacts. So we're doing our planning as we speak right now, and we'll see when the rule is finalized what its time frame is and how our assumptions are played out in reality.
If finalized as proposed, the new rule would require significant training for adjudicators who will be required to gain new expertise in complex areas of public benefits, including state Medicaid programs. However, the proposed rule includes no time or cost estimates of the necessary training. Has USCIS estimated the costs for training and implementing the new rule? If so, what are these estimated costs?
I don't have an estimate for you, but I would say that one of the first things that I did when I joined the agency in 1997 was do the public charge rule that we did at that time based on the 1996 Act, and it's very similar, where we had to teach our adjudicators to understand what public benefits were and how they impacted this benefit. So we do something very similar, and I say that to illustrate that we are accustomed to policy changes or statutory changes or process changes and bringing our people through that with the goal of implementing it as efficiently as we can and as consistently as we can across the hundreds of thousands of applications that we'll get. So we're working on it now.
And your customers will have to shoulder the burden of the new, of the added costs, correct?
Gentlelady's time has expired. The gentleman may answer.
Correct.
Gentlelady from Pennsylvania is recognized for 5 minutes.
Thank you. I just wanted to make clear that CIS is the agency charged with processing applications of people who are trying to follow our rules and become legal residents or get work authorization or become citizens, right? Okay. So they're not people hiding from the government. They actually are providing a lot of information to the government as they seek to have those applications adjudicated, right? Mr. Hafer, I'll let you speak for the group. Thank you. And until they get citizenship, they can't vote, they can't receive Social Security benefits usually, sometimes people can't work. I mean, there are a whole host of benefits that are attendant upon becoming either a legal resident or a citizen, correct?
Yes.
Okay. We talked a little bit about the delays and some of the factors that led to the burgeoning backlog, and I think you mentioned the increase rather than decrease in citizenship applications following the 2016 presidential election, right?
That is correct, yes.
Okay, so after a presidential election, there's usually some kind of drop-off.
Yes.
I can help you with why that happened. As a legal services attorney, immediately following the election in 2016, we started encouraging people to obtain citizenship if they were eligible due to the anti-immigrant rhetoric coming from the administration, and I think the administration helped deliver that message pretty forcefully when the first executive orders to come out of this White House were to ban travel by people who were from predominantly Muslim nations and to completely upend our deportation priorities, going from just excluding bad hombres, as one might call them, to anyone who did not have permanent legal status under our laws. So there was a huge incentive for people to try to file their paperwork and get whatever status they were able to. But I don't think you mentioned some other things. One thing that I noted in going through some of the testimony, the Inspector General did mention that the electronic documentation services, Ellis I believe it's called, has had some serious deficiencies that have also slowed down processing, correct? Whose is that, Mr. Valverde?
Yeah, I can speak to that because we used it for citizenship and also for replacement green cards. And I know for citizenship in the, I'll get my years wrong, in the 15-16 timeframe when we were implementing it, it was a much slower implementation because of some of those difficulties that you're referring to.
Okay, and the Inspector General's report was from November 2017, at which point those difficulties were continuing, weren't they?
I believe that's the right time frame. Shortly after that, we had pivoted back to using the system, and we've been using it since.
So you had to resume using a system that you'd been trying to upgrade because of deficiencies in the new system?
We had started to use it and then decided it was better to fix it and pause for a while and then resume using it when it was working the way we intended it to.
And that's during a period of time that was central to when this backlog started to really explode, isn't that right?
It was while the backlogs were growing, but I would note that we had a parallel system, the older system we call Claims 4, without getting too much into the jargon, that we continue to use. So we did not sit on our hands. We had work to do during that time as we improved the Ellis system.
Okay, but it contributed to the backlog, right?
I think that's fair.
Okay. What you didn't mention was there have been a lot of policy changes during the course of this administration that have impacted your ability to process applications. Isn't that correct?
There have been a number of policy changes that impact our.
And they would include additional REIs or RFEs, requests for evidence, that were not previously required?
The policies didn't direct that we would issue more requests for evidence, no.
There has been some suggestion that the requests for evidence have become duplicative in some cases? You haven't heard complaints that you're requesting evidence in duplicative manners?
Oh, that sometimes a request will be issued and then followed by a request for the same evidence?
Yes.
That I'm sure that in the millions of cases we process that mistakes are made, but that's not a common.
As someone who's had to submit their attorney representation file 6 or 8 times on the same case, I think there are some issues with that. Another policy that would seem to have increased time for response would be eliminating the 90-day deadline for processing employment authorizations, right? If there's no longer a deadline, can take longer?
No, that didn't drive how much longer it takes to process cases.
Okay.
The gentlelady's time has expired, but we will, we got an answer to the last question?
Okay, thank you.
Okay, then I will, the ranking member has said he will pass on this round of questions, so I will go to my questions, and I think we are expecting a vote on the floor very soon, so we will have to come back for the second panel after that vote. I'm concerned about how the processes have changed and the impact on the administration of the benefits program. Obviously, everybody wants a system that avoids fraud and adheres to the requirements of the statute and the like, but I just have some questions about the impact in certain cases and where the delay really eliminates the value of the program itself. For example, the OPT program, Optional Practical Training Program, by regulation, the earliest that a student can apply for OPT is 90 days before the end of the educational program. And I've heard that the delays are so extreme, 5 months or more, that in some cases you've got a student who's graduated from college, they're going to go on to their PhD, they've got their internship, the internship is over before they even get the approval of OPT to do it. So the whole idea of having this program is undercut by the delay, and so you sort of wonder what is being achieved here other than to undercut what the agency wants to do because of the delay. I have concerns about what's happening on the employment side. We've had a number of questions on the family side, which is very important, but I'm seeing from the statistics that nearly 50% of all H-1B petitions received RFEs in the second quarter of 2019, and I'm wondering why. And I'll give you an example of, I come from Silicon Valley. I recently had a casual conversation with somebody I've known for many years, a serial entrepreneur. He's been CEO of very large companies, and now he's got a startup. And he had an H-1B visa holder that was renewing the H-1B, and instead of, getting the renewal, he got a question from USCIS, was this guy's PhD really well fitted to the job? His question was, what would the USCIS know about that PhD versus him as the employer? And secondly, why this big study on a renewal of an H-1B? He said, what changed? Was their first process wrong? And people are just feeling jerked around, for lack of a better term. And what we've got are Canadian recruiters coming into American tech centers and luring people away. The tech economy in Toronto is growing faster than the tech economy in Silicon Valley and Washington. And a lot of people think it's because of USCIS and our immigration policies. I'm wondering, can you tell me about why we're doing the RFEs that we're doing in the H-1B program and for renewals in particular?
So that one's mine. I can tell you that a number of changes have been made affecting H-1B processing over the last couple of years. I'm sure you're familiar with them. And so when there's a change that's introduced, we have to first, we train our folks, but we also have to educate the public on what the requirements are as we now understand them. And so whenever that happens, regardless of what context, it's pretty predictable that we'll have an increase in requests for evidence, perhaps an increase in denials. Usually over time, as the public becomes familiar with what the requirements are, and as our adjudicators become more proficient, then we usually will see that the requests or the impact of those changes to become more stable.
Let me ask you another question. Somebody said, why don't we have some judgment being shown in these cases? We know that there are entities that abuse the H-1B program, and there's not going to be a single person on this panel that says don't scrutinize that situation. We all agree on that. But then you've got situations where that's not the case, and you have people who are being denied, and then they appeal, and they win their appeals every single time. And so what's happened is you've just added money and cost, delay for no outcome. Is there any analysis going on where the appeals are always successful and the denials are always wrong, and to do some assessment on what you're doing here?
So I won't say that there has been a study of the decisions coming from the AAO, but I will tell you that those, as we receive decisions that from the AAO that overturn the decision of the adjudicator, we do review those and determine whether is it a training issue or is it some other guidance that needs to be clarified or what have you.
Just a final question. I've also received a lot of complaints about the use of denials or FTEs as compared to the more informal notice of intent process that used to be more prevalent. For example, I've had tech people say, you know, there was a clerical error on the application. And instead of calling up saying, was it this date or that date, or, you know, was there a typo on this line, they request an evidence, or they deny it even worse. So you have to go through a whole expensive process. Why is that? What's the value in that?
So I think this gets back to the change in policy that we were discussing previously. And so the prior policy did require that it pretty much in every circumstance, even if the record seemed to be, you know, fully there, that a request for evidence would be issued. And the policy changed and allowed for folks to go straight to a decision if they felt that the record is complete. I don't know that, again, I don't think we've done a study to determine the impact in, as far as how many cases have gone straight to denial as opposed to having a request for evidence issued in the interim. I would imagine that we could get data on that.
Well, since I have asked others to keep within their 5 minutes, my 5 minutes is up. So I will note that we've also been called to a vote. We have additional questions. Oh, Sheila, you came in later. Before we end this hearing, let me turn to Ms. Jackson-Lee for her 5 minutes, and then we will have enough time to get to the floor. Gentlelady from Texas is recognized.
I thank the chair, and I thank you for holding this hearing. I want to just, to the witnesses, USCIS has acknowledged that some policy changes have slowed processing and increased the overall case backlog. Is USCIS, and I know we've had probably a series of questions like this, making any efforts to improve data collection and analysis to better understand the impact of future policy changes on processing time and case backlog?
Yes, sir. We do reviews, looking back in time to see how the policies affect, and certainly when we have information about the various policies, we try to make estimates of how long things are going to take. So we regularly do reviews every year of this nature.
So what is your backlog now? If you said you had to give a landscape across the nation of how many backlog cases you're dealing with, do you have a handle on that?
Yes, we have 2.4 million cases in backlog, and overall we have about 5.9 million cases pending.
And those individuals, do they have a document indicating pending case? Are they subject to the actions of immigration enforcers because they're not statused? Or are you continuing to provide them with updated paperwork that their present status is due to your backlog?
I can take that. So everybody who files a petition or application with us will receive a receipt, and that will indicate that their case is pending. Depending on what they're applying for, that might provide them status or some protection from removal. It depends really on what their status was before they applied, what the status is that they're seeking.
Employment authorization delays have been substantial. Delays in employment authorization have significant impact on many different stakeholders and can result in prolonged benching or even job loss. Families are put in disarray because families are dependent on the person seeking the employment status. Do you have any way of channeling the employment request? Because these people will have a legitimate base of income. They've got family members that are dependent on them. Is there any way to stovepipe those requests?
So we are concerned with the processing times for employment authorization documents, and one of the things that we did was provide for auto extensions. So if somebody has an employment authorization document and they need to seek an extension, depending on the category, then they can receive an automatic, their old card is automatically extended for a period of time while we process their case. That was one of the things that we tried to do to provide some relief. But we also, it's one of, this category of work is very important, but it also competes with the other categories of work that we have with our limited resources. So I can tell you that we do prioritize it, and compared to other processing times for other applications, the EADs typically are handled much more quickly, but not as quickly as we would like.
Well, would you consider going back and analyzing to how you would resource the employment request in a way that you might recommend that would help you move them faster. Certainly vetting is important, but move them faster.
Yes.
Are you all appointees or civil servants?
Career civil servants.
Well, first of all, let me thank you for your service. I've probably run into you before. Are you noting the disparate directions that seem to be coming from the administration, impacting staffing, impacting immigrants who are coming in or not showing up? In terms of the disparate, frankly, I don't know whether this administration is for any immigration. I don't know if they're for legal or illegal, not illegal, but helping undocumented, helping people who are in the country. I have no idea. That sets the tone for the work you do and also for people accessing your services, which are very important, and the funding that we in Congress pile on to the administration. I'm not sure if it's reaching you because I noticed that you have staff turnover. What's happening with staff turnover and the people that come in that you see?
Staff turnover, we actually, like any agency, we experience attrition, but that is not, I don't think that's a huge concern for us. The difficulty for us is in terms, hiring can take several months. Not only then to bring somebody on board, but then after that to get them trained and experienced.
So you have the resources, Congress has given you the resources to hire as you need?
We're fee funded, so we don't usually need to look to Congress to authorize our staffing levels.
And so you can expand your staffing levels if necessary?
With the fees, yes.
Right. And you'll look to the stovepiking of certain employment
Gentlelady's time
documents.
has expired.
Yes. I mean, processes. Thank you. I yield back.
Thank you. The gentlelady yields back. I recognize the ranking member for unanimous consent request.
I ask that a statement from the United States Chamber of Commerce dated July 16, 2019 be included in the record.
Without objection, so ordered. I would also ask unanimous consent that the following statements be made a part of the record from the American Council on Education, the American Immigration Council, Assistant in the Asian Pacific Institute on Gender-Based Violence, the Association of American Universities, Boundless Immigration, Church World Services, the Compete America Coalition, Forward Us, Her Justice, Invest in America, National Immigration Forum, Unitas US, the National Partnership for New Americans Report to REAR, and the, again, the Information Technology Industry Council. And without objection, those statements are made a part of the record. Just as a parting comment, I think planning ahead is something that would be very helpful in terms of changes of policy. I think you heard from many of us when the premium processing policy was changed after the applications had already been mailed on a Sunday when the due date was Monday, and people had to rip checks out of and rewrite them. People whose applications had already been sent were rejected because they had more money in the fee. It's just a crazy way to run an outfit. I know it wasn't your decision, but that kind of stuff just creates chaos in the community, in the business community, and is counterproductive in terms of a good economy for the United States. With this, we will recess until after the vote. We will have 5 legislative days to submit additional questions to each of you. We would ask, if we do, that you answer them promptly. We thank you very much for being here, and we will probably be back a little bit after 2 for planning purposes if people need to go catch a snack or something. So we are in recess.